Good morning. As I mentioned earlier, we are considering 4 cases today. In 2 of them, including the Chlarson case. Am I pronouncing that correctly, like Larson with a CH on the front? Chlarson?
Your Honor, it's Chlarson. Just pretend the CH is a K.
Oh, well, thank you. A silent H, if you will. Chlarson. Thank you for the clarification. And we think our argument will be of some assistance to us in this case. Appellant can save some time for rebuttal. It appears that you're going to save 3 minutes.
Yes, Your Honor.
And I think you've both been here before. You have been here before. Have you been here before?
11, 12 years ago, Your Honor. It's been a long time.
Well, things have changed dramatically. One of the
Except
things
for
that
one constant, right there.
some things have changed, including the way we do our preservation of our record. We're a constitutional court of record, so our proceedings are necessarily recorded. It used to be we made an 8-track tape or CDs or something. Well, now they're live streamed, and so there are people out there right now potentially listening to these arguments. We can go back and hear the arguments anytime we want to. So it's very important that you don't stray from the microphone while making your argument, or it won't get picked up. It's also important that each time you come to the podium, you state your appearance for the record. In case we go back to listen to a part of the argument, it's helpful for us to know who is saying what, when. The other thing is that if you're answering one of our questions, it's time to sit down when you see 3 zeros on the clock. But if you're in the middle of answering one of our questions, carry on. You don't need to ask if it's okay. Yes, it is, because we want to hear the answer to the question that we asked. Don't take advantage of that and launch into some other point. But if you're dialoguing with the court, pay no mind to the clock. Otherwise, when you see zeros, it's time to take a seat. Any questions about any of that? Anything I've left out? Very good. Then whenever you're ready, we will hear the argument in Chlarson v. Chlarson.
Thank you, Your Honor. May it please the court. Good morning. I am J. Ed Christiansen. I represent the appellant, Sergeant First Class Justin T. Chlarson, United States Army, retired. Both the parties have briefed a number of issues, but the final resolution of this case rests solely on the singular issue of whether or not retired pay under Chapter 61 of Title 10 is included within the definition of disposable retired pay. The Uniform Services Former Spouses Protection Act, found in Title 10 United States Code Section 1408, gives us the answer to that question. Under subsection C, Congress has given authority to state courts to divide what is termed as disposable retired pay. In subsection A, various definitions of the statute are included. Specifically, in paragraph 4, the definition of disposable retired pay is defined. And yes, Your Honor.
The more I've thought about your case after reading your briefs, I served for a decade on the district court bench, and one thing kind of stuck out on this case, and it's kind of the procedural posture of the question you're asking us to review. The parties were divorced in December of 2021, and I believe that the retirement, or the disability and retirement final decision was it 60 days later or something like that?
Yes, Your Honor.
Okay.
Sometime later.
The law didn't change.
No, Your Honor.
Okay. So knowing that that's pending, was there any was there any onus on your side of the fight to advise the district court as to what this law might be? In other words, within the contemplation of the parties, was there any duty to say, well, Your Honor, you need to make this retirement ruling contingent, because if it goes one way, depending how it comes down, the law will dictate this? And because I think that you, I want to get my numbers right. If this was a normal Section 7314 retirement, you don't have any dispute, then it would be divisible.
That's a good question, Your Honor. And to be honest with you, I don't know the answer to that. I wasn't involved with a case prior to the divorce or prior to the final retirement. I'm unaware as to what discussions there may have been between counsel and client, and that with respect to opposing counsel and opposing party. I don't know if either party was even aware of the specifics of the law.
Okay, well, I'm going to ask you a very long question now. Try to stay with me. If we could have had a scenario, and I've seen cases, obviously we have quadros in domestic cases, which are ubiquitous, that are ordering a third-party entity to do something. And maybe the functional equivalent here would have been an order telling DOD, this is how we want something to be paid. And if it turned out that the trial court had ordered DOD to do something that the statute didn't compel, there you go. On the other hand, I believe that the order in this case says that this stuff's happening over here with retirement, but what the bottom line on the ground order is for Mr. Chlarson, based upon what that calculation is, to make the payment. And here, we aren't in the status of a petition to modify, although I've looked at the record, and not only is there a petition to modify on this very issue, but there's, I think, a pending motion to amend the petition to modify. I didn't read all of that, as compelling as it was. But we're here in an enforcement action, and you're not claiming, I don't think, correct me if I'm wrong, that's why I said it's a long question, I don't think you're claiming that the district court erred in enforcing the decree wrongly, as far as the language of the decree goes. You're just saying that calculation to the side shouldn't be the way it is. Do you understand my question?
Yes, Your Honor, and I believe your question would be more applicable if we were looking at the issue of alimony. In other words, here's some asset, however we describe this asset or future asset, that Justin may have. And for purposes of alimony, could it be considered? And the answer is absolutely yes, whether the parties contemplated that beforehand or not. But for the purposes of dividing property, it's a moot issue.
So are you telling me on the record right now that your currently pending petition to modify is moot on this issue?
No, Your Honor. What I am saying is that because Congress has declared that retired pay under Chapter 61 is not an asset that a court can consider for purpose of dividing property. It's not marital property.
Let me take a different try then. Why shouldn't that be, as it apparently isn't the case, why shouldn't that be an issue of a petition to modify as opposed to an issue of enforcement? I think your answer is, I always try to guess what your answer is going to be. I think you're going to tell me a petition to modify is great for the future, and maybe even back to the date that it was originally filed on, but that gives me no help in that period between January of 2022 and whenever the order of the court. Is that what we're really talking about?
Yes, Your Honor, and I suppose either party could file a motion or a petition to modify.
Well, you have.
Yes, Your Honor, but with respect to this, the best I can answer is to give the analogy of a recent Supreme Court case where Howell v. Howell, kind of a similar case, but the issue in Howell v. Howell was that in the agreed upon divorce decree, the parties said, hey, spouse, you get 50% of the disposable retired pay. However, should I voluntarily waive part of that for waive part of my taxable pay from DFAS in favor of my untaxable VA's disability compensation? I promise to indemnify you for what you would have gotten had I not waived that and received this other thing. The Supreme Court in Howell v. Howell says, no, not so.
This is our Supreme Court.
The United States Supreme Court ruled in Howell v. Howell. I can't remember
So
the
I'm
year.
not seeing this in any of the briefing. Was this cited in the briefing?
It's not. The only reason I'm bringing it up is because of the question being posed to me right now. And that's the best analogy I can make, is that the Supreme Court says even after the fact, similar to a motion to modify, you can't go back and indemnify or give the other party something else to compensate them for what they would have received had there not been this issue about disability pay.
And can I go back to a question that I think Judge Mortensen was asking, but I'm not sure got answered? I think his question is that the only reason we're here is because of the disability piece of this retirement, right? If he had retired after his 20, just of his own volition, there's no dispute that would have been an asset that was divisible in the divorce and that would have been properly subject to the court's order in the decree. Is that
Yes, Your
correct?
Honor. We wouldn't be here had Justin been able to voluntarily retire under Section 7314, which is for enlisted members of the Army retiring after 20 years of service.
Right, and so your position is just sort of high level, that when there's a disability retirement, that it essentially insulates the entirety of his retirement from any distribution to a spouse.
Yes, Your Honor, because that is the plain and unambiguous verbiage, the plain and unambiguous language in Clause 3 of Paragraph A of subsection.
But this gets back to my question of it. Great, that's what the law is. Why shouldn't your client have pressed that issue at trial, or as it's happening now in a petition to modify, but in an enforcement proceeding? People stipulate all day long to things that are not actually sustainable in law. And when they show up and say, I don't want it enforced, with a somewhat unified voice, the appellate courts in particular, usually say, well, that was your deal. I mean, if you want to do something about it now, that's different. But in an enforcement scenario or context, is that the time to say, oh, I'm sorry, this no longer applies? Or should it have to be through a petition to modify?
That's a difficult question to answer, Your Honor. And honestly, I don't have the exact answer for that. All I can say is perhaps either party could have or should have known. It was known that during the pendency of the divorce itself, that Justin was facing the possibility of a medical retirement.
But that makes my point, actually, is because that's clear in the record that this disability retirement was pending. So knowing that that's pending, that means that, we're going to put on both sides a knowledge of what the law is. And so when the court's wrestling with these issues, I guess there's three ways it could or a couple ways it could come out. One is a petition to modify. The other is when the court made its decision, if this law is sitting there that under I want to get my sections right, under chapter 61, this is not something that can be divided. Isn't that the time when the court issues its decision, if they got it wrong, to appeal? Or do you have to wait? Yeah, I guess.
I think the answer, Your Honor, is no matter what may have been decided at the trial level, the fact of the matter, when it came to the motion to enforce, there was nothing to enforce because there was no disposable retired pay. It didn't exist. In the divorce decree, it may have said that the other party gets 50%, but the fact of the matter is, whether either party knew it at the time, the law says that retired pay under Chapter 61 is expressly excluded from the definition of disposable retired pay. So when it came time for Justin to, or DFAS for that matter, and we know DFAS wouldn't have, but for Justin to make payments, there is no payment to be made because there is no disposable retired pay from which to be divided. I suspect that your concern perhaps may be from a fairness issue. And all I can say with respect to that is this court, in ruling in Thayer v. Thayer, said that when it comes to dividing military retirement, we have to follow the express language that Congress gave us in allowing certain things to be divided.
Thank you.
Thank you, Your Honor.
Our questions are what put you over your time, so you'll have your full time on rebuttal.
Thank you, Your Honor.
And we'll hear from appellee.
Thank you, Your Honor. Deborah Bulkley for appellee, Jacqueline Chlarson. Your Honors, I agree that this is something that there are a lot of preservation issues here. We've raised some of them in your brief, and you've raised another one, Judge Mortensen, that really, when this should have been, why this wasn't addressed sooner, why this wasn't addressed at trial, I don't know. It probably should have been addressed shortly after the trial, but it was not until my client moved to enforce the divorce decree that was then existing. And there are, the argument on this has been evolving from the appellant, but really there is just one issue on appeal here, and that is the federal preemption issue. And that is whether federal law preempts a service member's, or preempts a state court from dividing a service member's retirement pay when that service member also receives disability pay under Section 1414, which is the concurrent retired and disability pay. And I think that...
Do you acknowledge that for a time before Congress fixed it, that this wasn't divisible property?
No, Your Honor, there has not been a change by Congress. As far as, before the Uniformed Services Former Spouses Protection Act, then it was not divisible, but that was passed back in the 1980s.
Right.
And
before that.
Before that, yes, Your Honor. Before that, retired pay was not divisible by a state court. And there was a Supreme Court case that decided that, and then in direct response to that Supreme Court case, Congress decided that there were circumstances under which retired pay should be divided. And they came up with Section 1414, and that is what allows the state courts to divide what is defined by federal law as disposable retired pay. Now, there are a few exceptions in the law to types of retirement pay that count. And the one at issue here is for Chapter 61 retirees. But if you read the statutes together, this 1408, which is the, and I may have cited the wrong code section before. 1408 is the Uniformed Services Former Spouses Protection Act, which allows for the division of disposable retired pay. And then there's 1414, which is the Concurrent Retired and Disability Pay Act, which is a fairly recent enactment. And that one is commonly referred to as a CRDP statute. But basically, under that statute that allows certain qualified service members to receive both the retirement pay and the disability pay. So we're talking about two different types of pay here that are paid by two different agencies. And we attached to our brief to illustrate that Addendum C, which is the Department of Defense pay stub, which shows that the retired pay for Justin was reduced by his VA disability waiver. Now, we're not trying to touch any part of that VA disability waiver. It's well settled that that part of the retirement pay that's waived is not divisible, and I believe that is the Howell case that was referred to earlier. Basically, we're not trying to touch any disability pay that's paid by the VA. We're not trying to touch any retirement pay that was waived to receive that VA disability pay. The only thing we are trying to touch is the actual retirement pay that Justin is receiving.
And is that just to help me put a number on it, that's the 2577?
Yes, Your Honor.
That's right, and that's after the VA waiver piece has been taken off.
Yes, Your Honor, and you can
Okay.
see on that pay stub, and there's a separate stub on Addendum D, which is the disability pay, but you can see that there is a reduction of a little over $1,000 in his retirement pay, because that is the amount that was calculated using his disability. And I think that's the important
And
distinction
you're
here.
not trying to have that somehow imputed back in and taken into account?
No, but it's an important distinction, Your Honor, because it's why the plain language of the statute supports our position that this retirement pay is divisible on divorce. Because basically, VA disability pay is special. It is unique in that it cannot be taxed, it cannot be divided in a divorce. And so oftentimes, if there's a service member that's eligible for either or, which until the CRDP they had to pick, they're almost always going to pick the disability because of those advantages. But in this case, a member gets both retirement and disability. So it's different. The service members that qualify for this program are in their own special category. And the reasoning, the reason that this is a special category is because they get both, and but they're only entitled to, if you look at section 1408, it doesn't exempt all Chapter 61 retired pay from disposable retired pay. If Congress wanted to say, if you're...
That's what the court in Alaska thought, though.
That is what the court in Alaska thought, Your Honor, and I believe the court decided wrongly. I believe that the cases we cited, the board, the Claims Appeals Board decision, and then there's the,
We'll call it the Doha.
the Claims Appeals Board decision from the Department of Defense hearings, the administrative court, and then the Sheehy case.
Is that binding on us?
No, Your Honor. I don't believe there is any authority on this point that's binding on this court as far as how it's going to proceed with its statutory interpretation. But I do believe that decision and the Sheehy case are persuasive. And the reason is because Chapter 61 retired pay, like I said, Chapter 1408 says it only exempts Chapter 61 retired pay that is calculated using the service member's disability. It doesn't say all Chapter 61. Congress could have very easily said, Chapter 61 retired pay not divisible, period. But they didn't. And then if you look at the CRDP statute, that statute says that a service member waives their pay that's calculated using disability to the extent that it exceeds the time-based pay. Now, time-based pay is how most service members receive their retirement. If they're not receiving the retirement that they can elect under Chapter 61 that's based on disability. So basically, what that court ruled, and I think that that's a reasonable, fair, plain language reading of the law, is that once you have, are receiving both of these retirements, you're essentially receiving the time-based retired pay. You're not receiving retired pay that's based upon your percentage of disability because you're waiving that to the extent that it exceeds the time-based pay. And so the exemption for Chapter 61 retirees doesn't apply because it only applies to the disability-based retired pay. I think I think that the trial court correctly found the reasoning of that, the Claims Appeals Board decision to be persuasive. And another reason why the Claims Appeals Board decision ruled the way it did was because there's another statute that was enacted very close in time to the CRDP, possibly simultaneously, which is the Combat-Related Special Compensation Act, which is Section 1413A. Now, that act has a very similar carve-out that says, that the member waives any pay, retirement pay, to the extent that the disability calculation exceeds the time-based calculation. But then it also says in subparagraph G, and when I was looking back through my brief, I think I may have cited the wrong subparagraph there, so I apologize. It's 1413A subparagraph G that says the pay that is received under this section is not retired pay. And so it's clear that with one section, Congress intended to keep the general retired pay the general retired pay character for the retirees in place. And under another section, it did not want to keep that in place. And so I think that that's an important distinction because Congress could have said, yeah, we want to treat everything that a service member receives as disability pay, but they did not. They said, we want there to be a retired side and a disability side. And the retired side is what they would have received under a time-based calculation. And the statute that allows for the division says, we're only exempting Chapter 61 calculated based on disability. It doesn't say Chapter 61 retired pay. I mean, I think for the argument that Justin is making to be correct, the statute, as a plain language reading, the statute would have to say Chapter 61 retired pay is exempt, period. But it doesn't say that. And this is a change in the law. Previously, before CRDP and before the Combat-Related Service Members Special Act, all of this pay was an election, right? You had to pick one or the other. You had to have retired pay or disability pay. And so under that circumstance, the retired pay really, for service members that qualified for both, they would take as much disability as they could, and the retired pay would just be what's left over for whatever disability they don't qualify for. But now under these programs, the qualified service members receive both. So basically, they're getting double pay. And the argument that's being made here today by the appellant is that for these service members, this otherwise divisible retired pay that's based on time, calculated based on time, is no longer divisible. And so I believe that it's rather than, so I think that the plain language reading is that the retired pay should be divisible. And I do think that that is the plain language reading in the statute.
Can you As to the case out of Alaska, one of the things they said is they said that the nature of the payment isn't changed by CRDP. I know you disagree with that, but why, explain to me why they were wrong.
Your Honor, when I read that case, I think that there is a confusion, and I think that it's easy to confuse because the VA, or sorry, the Department of Defense, in its, policy manuals, kind of classifies different types of retired pay. And the retired pay you receive under Chapter 61 can either be calculated based on your time or your disability. And most often, it's calculated based upon disability because that's usually the more advantageous way to do it. But it's still retired pay. And the CRDP doesn't necessarily change that, but what it does change, and I think where the court got it wrong is it's saying, well, disability pay is still disability pay. Well, that may be true, but it's calculated differently under CRDP. And so I think, and looking back at
Their
that.
conclusion was how you calculate, I think that was their bottom line. That's math. How you calculate it doesn't change the nature of where it comes from, I think is what the Alaska court was saying.
Yes, Your Honor, that's true. But the plain language of the statute kind of makes that calculation critical because it says the time-based it says the disability-based calculation is exempt from division, but the time-based calculation would not be under Chapter 61. And so I think that the court there
Oh, I see.
missed
You're
that
saying that
distinction.
Since it has a component of time-based within it,
Yeah, yes, Your Honor.
I see where.
Yeah, because the disability pay, if we're talking about pure disability pay, that's paid by a different, that's paid through the VA. That's not paid by the Department of Defense. It's a separate payment. And so we're not saying that that is what we're trying to divide. And I think that the Alaska court may have misunderstood that very important distinction, Your Honor.
Thank you. No other questions, it appears. We appreciate the argument, and we'll hear, excuse me, I shouldn't get choked up over the mere mention of rebuttal, but we will now hear appellant's rebuttal.
Thank you, Your Honor.
3 minutes, according to the clock.
I assume, counsel, that you agree that the Doha decision's not binding on us, right?
Not binding, not applicable, nor is it even close to being persuasive, Your Honor. And thank you, Your Honor. I'll do my best not to choke you up any further. But really, what needs to be clarified as to the argument that's just presented, yes, the Clause 3 exclusion in 1408 doesn't say all Chapter 61 paid. It says Chapter 61 retired pay to the extent or an amount equal to what, using the disability rating, which was 100%, the max could have been 75%. That's more than some other formula could have done. Thus, in Justin's case, that Clause 3 exclusion applies to all of his Chapter 61 pay, to clarify that of what 1408 means. But more importantly, words have been thrown out about 1414, especially words such as plain language. What does the 1414 actually say? Nowhere will you find within its plain language anything that says time-based. That is not a consideration. It's not a phrase that's used, nor does it even apply. The first paragraph in 1414 allows those with 50% disability rating or more to concurrently receive their VA disability compensation and their military retired pay, no matter what chapter it came from, 61 or any other. It allows those members to collect both without a waiver. But in Justin's case, there is a special rule found in subsection B, paragraph 1. And here's where we keep bringing up plain language. Appellee would have you believe that the plain language would say, oh, something time-based, that's the reason we enacted the statute, and therefore, after whatever special math there is, what remains of the Chapter 61 retired pay is no longer Chapter 61 retired pay. That's not how 1414 works. That's not what it says. What it says with respect to this small group of people that are above 50%, but also happen to have 20 years service, that they will suffer a reduction. Not the same reduction that others would, a dollar for dollar, but the reduction would be the difference between what their retired pay is and what it would have been had they retired under some other provision. And that doesn't have to be a time-based provision. You could find several other aspects in the law or provisions where a military member can retire for whatever reason. Age being a reason to retire. Time in service can be a basis, or failure to be promoted to another rank can be a basis to be retired. But Justin could have retired had he been not forcefully medically retired. He could have retired under 7314, which just happens to be a time-based retirement. But that's not what this says. There will be a reduction. He will waive, in order to get his Veterans Administration disability compensation, he will have to waive some portion. So to get his 3,000 plus, he has to waive 11 or 1,900 and odd cents. But it doesn't say anywhere, nor does it suggest, and what's left, the remainder of his Chapter 61, his retired pay under Chapter 61 is no longer considered Chapter 61 retired pay. It doesn't say that. It doesn't suggest that. That's not how it works. The remainder is still his remainder. Why did Justin retire? Because he was found no longer to be physically fit to carry on his duties. Thus, he was retired. The Army retired him under Section 1201. And what needs to be clarified here, Chapter 61 is the chapter that you can physically or separate somebody. Chapter 71, which contains both 1408 and 1414, the title of that chapter is Computation of Retired Pay, based on other statutory bases to retire. It does not provide a basis to retire. It does not reclassify or modify whatever you're paid from some other statutory provision. I'm sorry, I see that I'm over, but I would like to finish that sentence in that yes, there will be a waiver, a 1414B1 waiver for him to collect both his VA disability compensation and the remainder of his Chapter 61 retired pay. But what's left is still Chapter 61 retired pay. And it doesn't matter that it just happens to be the same amount of money that he would have received had he retired under some other longevity or time-based provision. Thank you, Your Honor.
Thank you.
Unless you have further questions.
Apparently not. We do appreciate the arguments from both sides. They've been helpful, at least from my understanding of the case. We'll take the matter under advisement and let you have our decision as soon as we're able to get that taken care of. With that, we'll be in recess till tomorrow.
Thank you, Your Honor.